The hosts of this podcast are licensed attorneys, but we are not your attorneys. No. If you'd like to retain our services, please contact us to discuss your matter and execute a formal engagement agreement.
Let's get right into it. Welcome back to the Employee Handbook, a human resources podcast by two lawyers. I changed the name from HR podcast to human resources podcast for SEO purposes. So let's see if it makes a difference, right?
Yeah, 100%. And I like to celebrate 2026. We're talking about, you guessed it, strippers.
Oh, I can't hear anything. Well, Ryan is trying to play some sort of sound effects, but I can't hear them. And Matt will put them in later.
You couldn't hear it?
No, I couldn't hear a thing.
I held it right to the microphone.
No, I don't know. I'll just pretend like we're jamming over here. But yeah, no.
Insert cherry pie clip here.
She's my cherry pie.
Sorry, I just thought it was necessary given the stereotypes of that song and strip clubs. Okay.
But before you say anything, I just want to say we are so excited to talk about strippers. Very excited. We love strippers. Why? Because strippers give you so many different hypotheticals in the employment law realm. And it's something that we are going to explore today. Strippers. We're going to explore strippers.
Yeah, I call them by profession of exotic dancers.
But before they accuse us of being misogynists, our example comes today by way of Canada, and it's a male exotic dancer.
Yes, agreed. And it wasn't even in such an exotic dance that you would expect from the way that we're talking about it right now. So it's going to be a good show today, I think. It's going to be a lot of hypotheticals, like Arta said. You can literally go through almost any, if not all, sorts of legal issues with an exotic dancer and how they run those businesses, from contracts to business formation to bankruptcy to employment law to workers' comp to personal injury, all of it.
And yes, this nice example that Google found me from 2012 is a case from Canada. It's Newsham versus CanWest Trade Shows. Back in, I don't know, this is probably 15 years ago, this nice gentleman was operating sly strippers. And he sued CanWest Trade Shows after he blew out his knee when he slipped on an oily substance while performing at the naughty but nice sex show.
Insert P. Diddy joke here.
They found so much baby oil at Diddy's place, Johnson & Johnson sent him a thank you card and a W-2.
Go on.
So instead of paying booth rental fees, he had agreed to perform at the show because I guess he brought a booth and he was selling stuff. So he signed an exhibitor contract that contained a release of liability and some indemnification clauses on the back page.
Standard stuff.
And all standard stuff, exactly. And a little twist here for the facts to make it more interesting. He had significant pre-existing knee injury from 1998. And so that goes into part of our analysis here for whether or not the CanWest Trade Show owes him any money for him blowing out his knee on stage. So first thing, we want to just get this out of the way. As I said, he was an exhibitor there, and instead of paying exhibitor fees, Mr. Newsham agreed to dance at the show. So there was a waiver included, but the waiver applied to him only as an exhibitor. So we can get this out of the way. The waiver doesn't apply because here is a performer, and I'm not really interested in this stuff anyway because it's not the end, it's just contract stuff, which is just really fried. Unlike
that negotiation,
who was very oily.
Can you imagine that negotiation though? It's like, okay, you got a booth fee, $25,000. He's like, how about instead of that, I'll put on a show. Well, how many minutes? Well, you want a show or do you want a show? It's 6 minutes or 7 minutes, your choice. It's like, I'll go for the 7, see?
Yeah, $25,000 seems like a lot for a booth there, but yeah, I mean, they definitely got their money's worth because they'll never forget the show that he put on up there.
We gotta find a video. We gotta find a video of this.
Being hired pro getting splashed with oil
as Charlie Brown full send slip
goes down like Joe Theismann.
Like, I've been to a lot of conventions just like for clients or for whatever. Like, I'm just imagining like an exhibitor hall with like the end of it's got like this performance stage, and like this is a bunch of people with badges getting their like really crappy coffee and like walking over and seeing this show. You may look forward like
God is me. For an oil and dried paint.
they like look down on their like business casual shirts and it's like splattering of oil. They're like, how am I gonna explain this to my wife? Like,
That's a
they're just so disinterested. They're just gonna like, oh, is he okay? Oh, whatever. They walk around like, oh, look at that. They're giving away free zip drives over there. On those phone cases.
Get a zip drive after you see Mr. Newsham unzipped.
Okay, sorry. Laughter out of the way.
We digress. Okay, so a few things about the case. Mr. Newsham claimed that it was body paint that caused him to slip from other performances that were completed earlier in the night. The body painting demonstration occurred at 6:20 p.m. and Mr. Newsham was on at 10:40, 4 hours later. This thing goes long, no pun intended. And I guess there was other performances that happened in between, and there was no reported incidents. Newsham also admitted walking over the same area at least once earlier in his performance, and he didn't slip. He admitted to putting baby oil all over his body, as one does, before performing.
And that request for admission. Please admit you apply copious amounts of baby oil to your body before your performance.
Court found that it was equally plausible that any slippery residue came from his own baby oil as it would from body paint. That must have been quite a deliberation in chambers. Stage was carpeted, which is, that's weird.
Not very slippery.
Yeah, that's very weird. And the stage manager watched all the performances and didn't see Newsham slip. When he spoke to the show manager afterwards, he mentioned hurting himself, but said nothing about slipping on his substance. So that dramatically changes things. I thought this was going to be some hilarious slapstick, like do 3 flips in the air before falling down, like the Wile E. Coyote or something like that. But this is really boring. This seems like he just buckled his knee, or it says it's knee locked up. That's what he told the doctor. This is so boring compared to what we had pictured. But the rest of the podcast is good, I promise. Basically, the court said you were dancing around on carpet with a bad knee. You didn't even slip. Nobody saw you fall. And we're not going to award you any money. So the interesting question for us is, how would this shake out in California? Because in California, this would end up very differently. Mr. Newsham's relationship here with what is it called? CanWest Trade Shows is going to have to be looked at in a very different light due to California laws being very different from Canadian laws. So Ryan, why don't we jump into a little bit of the analysis? What's the first thing, if this happened in California, that we would look at between the relationship of Mr. Newsham and CanWest here?
Yeah, so in California, just as an overarching theme, my answer, which is that whoever is being sued by the person claiming to be an employee or hurt is going to lose. The employer will lose. 99% of the time they lose. And that's shown here by multiple cases that we'll talk about later. But after 2018, the case of Dynamics Operations West versus Superior Court established what we call in California the employer killer, which is the ABC test. The ABC test really makes simple, hence ABC, the test to determine whether or not an employee or a person is classified properly as an employee or an independent contractor.
And let me just stop you. Why is that important for employers? Why would you care if you're classifying someone as an employee or an independent contractor if you're an employer?
Well, all the things, as the rhinoceros said in Toy Story, all the things, all the questions. Because in California, if you're an employer, you have significant rights, versus if you're an independent contractor, you do not have those significant rights and protections. And so before the ABC test was a test called the Borello test, which had multiple factors. You didn't have to take all factors into account. It was really a court's weighing process as to the factors to determine whether or not an employee was an independent contractor. But Labor Code 2775 here in California codified the ABC test, where in California, a worker is presumed to be an employee. So already stabbing the employers, unless the hiring entity proves these 3 prongs of the ABC test. A, that the employee or the person is free from control and direction in performing the work. B,
And you
performance.
said direction, right? You
Yeah,
said free from direction because we're
free
talking.
from control and direction in performing the work.
I know I was trying to make a male strip club direction.
Oh,
Go.
direction.
This is a bad episode.
No. This is actually a very important episode.
It's
Free from what?
it's meaty. Okay, go ahead.
We have a girthy episode here. Okay. Free from control and direction in performing the work. Prong B is performs the work outside the usual course of the hiring entity's business, which we will get into a lot in a minute. And C, that the person or the person being hired customarily engage in an independently established trade, occupation, or business of the same nature. So in California, most of the time, and I say most meaning essentially all, the ABC test will cause the employer classification of independent contractor to fail. And again, the presumption is the person or I guess the hiring entity is an employee. So there's a lot to talk about on the ABC test. I don't know how you want me to make some more stripper jokes.
No, I think we've reached our quota for for now. I think let's talk about the prongs. Prong A, whether or not Mr. Newsham was free from control and direction performing the work while he was on stage at the trade show. So
Yeah. So I'm going to jump in on this one because although it's not as meaty as you say to talk about as prong B, the problem we have with, or the A prong essentially says, well, the person you're hiring can do whatever they want in performing the work. So like, for example, and this is a bad example, but it's an example. You hire this stripper, this exotic dancer to dance, right? You're a trade show.
I'm with you.
What?
I'm with you. Still with you.
Yeah. So you have this trade show, which means you have a scheduled order of events. So prong A, you're going to hire this guy, again, assuming it's in California. As an independent contractor, you have to essentially say, look, we're hiring you as an independent contractor to exotically dance. And that's it. You don't get to tell them when. But here, because that's what the rule says, here, CanWest told him, hey, you're going on at 10:40 p.m. at the main stage, and you have X amount of time to do it. So, period. That they told him to do it. And then they're going to say, well, the counter argument there is that, well, we had to do that as an employer, or the trade show, we had to do that because otherwise, we just have a bunch of random exotic dancers running up on stage when it was convenient for them, and we needed that to comply with our performance schedule.
That would be chaos.
Oh my God. Can you imagine people fighting over the lube and trying to get on the stage and body paint flying and baby oil flying and people clapping? I don't know. It's like a WWE main event.
I think the problem is securing the rights to the theme to the Benny Hill show. I think that must be a budget. So prong A failed in that sense. So CanWest basically told them, get your groove thing up there at a certain time, shake it for a certain amount of time, and basically this was required for him to be able to have an exhibition booth there at the CanWest. What is it? Convention.
A trade show. But that's the thing is like, this is another example. And I know that I've been told to kind of dial down the I hate California speeches, but like, how do you hire somebody to do something without providing any dictation of guideline of how they perform the work? Like, that doesn't work, especially in California with how lazy people are. Like, a lot of just normal employees are lazy. So you go out here and you're like, look, I need you to do something for me. Yeah. Here's the money. I'm going to hand you like reluctantly over this money. So do it. But I got to like shut my mouth the rest of it. It's like, I told you to do X, now do it. And then just quiet and just hope that it comes. Well, that's insane.
But also, I mean, it seems like this is not a long-term agreement. It doesn't seem like either party here is contemplating a relationship that's going to last beyond this, dance that lasts, 5 minutes. So it also seems unfair to put this employer relationship on the trade show company here when each party is only contemplating being together for a very short amount of time. Just, hey, we have this one thing that we're doing and that's it.
Yeah. Which again is insane, because imagine just playing this out just from prong A. If you failed prong A, meaning that means you don't have to worry about B and C. The person is an employee and therefore is entitled to all the protections of employees in California. If you don't pay that person up front, then that person then is entitled to an hourly rate based on the amount of money that that booth might be worth. Let's say it's $1,000. So then there's $8,000 for that day. Let's assume that's the hourly rate that he establishes. And then if you don't pay that person within 30 days, you're up to a $240,000 penalty for not paying under the labor code.
Yeah, they have the new labor penalty, which triples, what is it? Triples the damages?
Well, not even tripled. I'm just talking about the waiting time penalties of the daily rate for 30-day cap. So like, if again, I've seen it where independent, I've had cases specifically, I can name them, I'm not going to, where I have tried these cases. And
do it, you wuss.
the person who was suing was a model for a photo shoot. And it was a flat rate for the day, but that person sued and the jury found that there was an employee, and they took the daily rate and made it into an hourly rate, which then caused my client to be penalized 30 days of that rate because the model wasn't paid, which is insane for a couple-hour photo shoot.
Exactly, because they didn't contemplate that model would be working every day like that. This was not a continued relationship that was contemplated. That's why this is a bit onerous, I think, just being generous there. So for prong B,
Sorry, can I make one last point? No, I want to address the haters out there that will say, well, then just pay. Like, you can do that, and that would avoid the penalty potentially from accruing. But remember, all the risk that an employer is taking by paying somebody who is not necessarily a professional and may be flaky and may not want to be there for whatever and just has all this money, they don't want to show up. So that's a big risk for a business to take. Sorry, go on.
That's all right. All right. So prong B, performs work outside the usual course of the hiring entity's business. So here we have a employer, CanWest, or well, I shouldn't say employer yet because we're pretending like we don't know yet. So we have an entity, CanWest, that is a business that is producing trade shows. And trade shows, entertainment is what they provide. They have a main stage schedule with acts throughout the day. Performers are basically what they are promising to people coming there to the trade show. They have a main stage with a schedule. People are expecting performers. Mr. Newsham is a exotic dancer. I think, Ryan, it's safe to say he fits the description of someone who performs work inside the usual course of the hiring entity's business.
Yep. Sorry, I'm looking up the trade show that they performed at, which is called the Naughty But Nice Sex Show.
Yeah.
So there's an argument there, clearly, that he was performing in the same industry of what this employer was, which was putting on shows, right? And that's what he does.
Yes.
Yeah. So I think, again, in California with prong B, the question isn't whether this person, this plaintiff, Newsham, is essential, but whether the type of work is what the business does. And that's it. And that's the killer, and that's the end all be all for what I said earlier, the foreshadowing of you will lose as an employer if you hire somebody to do the type of work that you do.
So
which is, again,
let's give an example of how this would look in the contra of this, which would be, let's say you are an accountant and you hire a cleaner to come once a week. Do you have a employer-employee relationship? Because this person is coming every week to your office. Say you agreed with them that it makes sense for them to come at 10 o'clock on Wednesday morning every week to clean your office. What does this pass B?
I think the accountant hiring a cleaner would pass B. I think that you have arguments on A and what we're going to, I guess, get into C, depending on the person you're hiring and the kind of work they do and the formation of entity, but which again we'll talk about. But I think it would pass B, because as long as in this example, the accountant hires this person to do the work that is not part of what the accountant does. So again, the accountant presumably in this hypothetical is doing accounting work, bookkeeping work, tax filing, stuff like that. The cleaner they're hiring is presumably not doing the same type of work. and it's not part of what the business does, then that would pass B. Now, I think, though, that a very shrewd plaintiff's attorney might argue, well, trash is incidental to the business, and therefore accountants are in the picking up the trash and cleaning. You have to clean your office as part of your employment practices. And I mean, you can make that argument. I don't think it would necessarily work, but there is an argument to be made.
Yes, I mean, that's the thing. It's more to point out how granular and absurd it can get because, like, for A, free from control and direction in performing the work, like, are you allowed to tell them, like, well, I don't want you to use a vacuum because it's too loud? You know, well, is that controlling their work? I don't understand.
Well, no, and I think you've hit a gold mine of information here, which I think you're right, is that you're not, Part A requires the control the employer. I'm going to say employer employee because they're presumably employees. Part A requires the employee to be free from control and direction in how they perform the work. So technically, again, granularly, the employee could come in and vacuum, and I'm using air quotes, with a leaf blower.
And you couldn't tell them to stop.
You couldn't tell them to stop because they have to be free from control and direction performing the work. Like, yeah, you could sue them later for like damaging your office or like for breach of contract for not performing the services, right? Or like not, you didn't clean my office, you made it dirtier, I want my money back. You could presumably do that, but you can't necessarily control them.
So I think like this is more for a situation. It's easier to contemplate. I think like if you have a cleaner that comes in at night while you're not there and cleans up, at like 2 in the morning, then you're not controlling them. You don't tell them when they get in there. They have a key. They can come at 2. They can come at 3. That's what California is really trying to impress upon employers as that's a true independent contractor relationship, and that goes with prong C as well. That the person performing the work is customarily engaged in an independently established trade, occupation, or business of the same nature. So if you say, well, I'm an accountant, I'm just hiring this person to come once a week to clean my office, and she gave me a business card that says Ann's Cleaning Services, and Ann has 30 other customers because she was actually referred to me by my neighboring office. So that's something where you're like, okay, this is an independent contractor, that they have their own business where they hold themselves out to the public in doing the service that your business is not customarily engaged in.
Yeah, and sorry, there's a leaf blower outside, so I'm trying to minimize my noise on my side. But yeah, agreed. That's why I came up with that example. So to twist what you're saying, I agree with you. But the next door suite mate in your office refers you to a cleaning company that does it. Imagine a situation where you have 50 employees, right? You have a pretty big suite, and you pay them good wages, but one of your employees also has a cleaning business on the side that they have 2 jobs. They work as an accountant during the day or a bookkeeper or whatever, admin assistant, whatever position, and then at night they clean offices. If you hired that person to do your work, would that be the same? Would you see that as a meeting prong C of the test, or would that be something that you might be worried about?
I would be very worried about it, especially in California, because I would feel that everything is going to be construed against me as an employer almost automatically. And plus, all the expectations that California has for investigations and the burdens that are put on employers for what they need to do. I feel like even if you had a chance of escaping some sort of liability, the way that you've conducted the investigation or didn't conduct an investigation subsequently is going to get you in trouble somehow too.
Yeah, agreed. And just to kind of bring this back to the case that we talked about, Newsham had his own business. Did you already talk about that? He had his own business.
Yes.
Yeah. Okay. So sorry, and I also just Googled when the CanWest trade show is going to have a Naughty But Nice show next, and guess where it's going to be in 2025?
Tell me.
San Diego.
Whoa.
January 28th to 30th, San Diego. Either Naughty or Naughty, KNOTT or Y or Nice, appears to be a specific themed art music event at a venue called Trade in Denver. That doesn't make any sense. Well, Google seems to be confusing, but San Diego 2025. Let's go see some Newshams break some knees.
I'm getting my thumb ready to hitchhike over to you.
But so I guess just overall, kind of wrapping the prong C up, is that prong C can be easily met. I think prong C is the easiest one to meet. So like you hire somebody to do something.
Meet for who? What do you mean?
Sorry. the easiest one to pass for an employer or hiring entity is C, because technically and facially, if you go out and you Google cleaning service in our accounting example, you Google you're an accountant, you need your office cleaned, you Google cleaning services in my area, enter. And the first things that come up are like, I don't know, cleaning service A, cleaning service B. You call the places, they have a business, they clean for other people, they have insurance, they have a bond, they have references, whatever you call the references, or not. But like, you hire this third party that you have no connection to perform cleaning at your office, pretty much you're going to pass the test, right? I think we can agree on that, that's the easiest one. Now, just because that's easy doesn't mean you're going to pass the ABC test, clearly, from what we said before. But I think the C of like, look, you're hiring somebody or an entity that's customarily engaged in an independently established trade, again, cleaning, of the same nature, cleaning, to do the cleaning work. Yes, that easy to pass.
Okay, so we've decided pretty much, since it's California, we already knew this was like the most obvious thing ever. This is like the hero, is going to win at the end, or the black character is going to die first in the horror movie. This is just like, it's inevitable that he's going to be an employee in California. But why? One of the reasons is that it saves California a ton of money if people are employees rather than independent contractors, because at that point, workers' compensation kicks in. Workers' compensation insurance is very important for keeping costs down for the state, and for employers, and for people themselves, and for insurance costs, medical costs. Because workers' compensation is basically a pre-negotiated, predetermined system where employees are paid much more quickly for injuries sustained at work than they would if they would have to go through regular litigation and prove negligence of their employer and things like that. So this is kind of, workers' compensation was developed as a almost like a bone to throw to employees. So, they could get money much faster and get on with their lives. So now that we know he's an employer, we have to decide, if you are Mr. Newsham in California, are you going to sue in civil court, or are you going to have to make a workers' compensation claim for your knee injury here? And of course, being Mr. Newsham, you want a personal injury case, because there's a lot more money in personal injury, because you can get pain and suffering, which you can't get in workers' compensation. And so let's go over a little bit first about which path you would have to take, workers' compensation or PI. So let's talk a little bit about that. Ryan, what do you think? Is he going to have to go through the work comp system, or can he sue?
Well, in California, I think if he's an employee, then he's going workers' comp. We talked about, or we didn't talk about, but there's something in employment relationships provide you with certain things you can and certain things you can't do. Here, workers' comp is an exclusive remedy for injuries against your employer. So what that means is that if you're an employee, like we've said in California, Mr. Newsham would be, he has to go and proceed for damages for his injuries against the company through workers' compensation, which would mean he has no personal injury lawsuit against CanWest. You don't have to do any analysis of who's at fault for the injuries, because it's a no-fault system. You don't get damages for things like pain and suffering and like punitive damages in workers' comp. But regardless of how that turns out, he will be compensated or provided benefits for what he suffered through work, for his damages for his knee here. So this, unfortunately for Mr. Newsham, is protection for the employer, where the employer has to have workers' compensation insurance, and then this injury goes through the work comp system, and that the what is it called? The CanWest gives up their, like, the defenses to, well, hey, this wasn't my fault because he did, he danced on a slippery pole, or he slipped on body paint, or he assumed the risk. In exchange, like, all those kind of claims and defenses are waived from the employer side in exchange for this, insurance covered, capped and predictable liability phase of workers' comp.
Yeah, and just to give people a little bit of perspective, it would take a long time to be able to attribute the percentage of negligence to the employer versus, say, like the venue that put the floor down versus like the oil company. Maybe they made it too slippery. There'd be all these different parties that you could point to for liability here, and percentage of liability. And this deals that all away. Now, instead of having to hire all these experts to prove this and prove that, it's just shown like, hey, you had a job at the time, you were injured on the job, it's going to be covered. It doesn't matter that you had prior injuries and stuff like that. We're going to overlook it. So in a way, it does benefit the worker as well. You get all the treatment you need, probably get a surgery. You get temporary disability, which is 2/3 of your weekly wages. It's capped, of course, at about 1,600 a week. But I mean, it's not the worst thing. Uh, you get paid while temporarily unable to work. Um, and you also could get permanent disability and supplemental job displacement benefits. So you do get some benefits of going through the work comp system, because if you were on your own, you would have to go through your own health insurance if you had it, and bear all the costs for the medical problems and then go sue afterwards, which, like I said, could take years.
And well, in speaking of kind of being provided benefits, like it's not just is it I'm not telling you it's not. Like is it one of those systems where like it doesn't matter, like he got hurt so he gets all these things, or does the pre-existing injury that he had with his knee come into play at all in the work comp system?
It does come into play in the sense that if you're in the work comp system and you have a permanent disability, you could get money to compensate you for that percentage of disability that, say, would make you less able to perform at a next job. Um, but in this case, being able to get medical treatment paid for would not be affected by the previous injury. Like if this was like a regular negligence case from a car accident, they could say, well, your knee was already busted up, so you didn't lose all this functionality of your knee from this accident. It already happened before, so we don't want to pay for all of it, or certain like that. There would be a point for them to be able to try to negotiate you down. Whereas here, they just have to take the pre-existing injury as part of the deal and perform the surgery.
So if I heard correctly, it's essentially that there's an apportionment analysis that is undergone in the work comp process, where if some portion of the problems existed before that he injured his knee on stage at the trade show, then CanWest would only have to pay in that situation whatever portion was not there before. So like if 50% of the problems existed before the work injury, then CanWest would have to pay the 50% of permanent disability if that was established.
Yes, and this all would have to be through experts and tons of different doctors, and he would have his own doctor, the company would have their doctor in a lawsuit, and it would take just absolutely years to get anything done, where this is also probably going to take a long time, but there is not going to be all the fighting over the causation aspect of it, which is usually what all the fighting is about in civil litigation.
Yeah, literally the entire thing. Um, and do you want to go through the process of how the work comp process is investigated, or do you just want to skip over that?
Yeah, I think we could do a quick thing of, again, I think we did an episode on this before. What happens if one of your employees is hurt at work? Yeah, let's just go through it. Ryan, what do you do? Let's say on the day of the injury, they come to you and tell you they're injured. What do you do?
Well, I think first you do is you have them administered first aid or send them to a hospital if it's an emergency. A supervisor would have to prepare some sort of incident report, and we can harken back to our if it was a dangerous condition that caused it, like a fight or something, we'd have to harken back to our episode on the dangerous conditions logs and the IWPP processes. And then you provide the employee with a DWC-1 form in California within one working day to make sure they're aware of their rights and what they can do or what they need to be doing.
So that's a work comp claim form. And now in California, you also have to inform your employees that they have the right to seek out legal representation in their work comp injury case.
Which is crazy too, because I mean, I have limited knowledge of work comp stuff, but I do know that one of the biggest things in work comp is when an employee is hurt, they assume the employer is going to help them. So the employer sends that person to their doctor or their insurance doctor, more specifically, their work comp insurance doctor, which I'm sure you can name a few of the companies that do that. But the number one goal for an attorney that represents the employee, the injured employee, is to get that employee out of the company or the employer's doctor to their own doctor. Is that right?
Yeah, basically, I don't know if that's the number one goal. I mean, your goal is not necessarily to advocate for them or prove where the injury is the fault of the employer, but your job is to make sure that the employee gets a doctor that is going to be favorable to plaintiffs, or at least not unfavorable to plaintiffs, and not just a defense shill doctor, which those don't really exist necessarily. Doctors, if you're listening to this, um, and uh, and just basically make sure that the insurance company is not taking advantage of them. So it's a little bit of a limited role. In a PI case, you're finding doctors um, and helping the client navigate the medical process, where this is just making sure that the insurance doesn't screw over the client.
Well, and I think that's where I was going to with, like, again, my limited knowledge. Don't quote me on these things, but like y- the employer doctor, which is covered by insurance, but obviously insurance companies don't want to pay. That's why they're so large. Just like casinos, they're very large because they don't pay jackpots a lot. But like they're going to send you to a doctor who they trust will really scrutinize the injuries and not provide palliative treatment unless it's something that's absolutely necessary.
Yeah, exactly. Their job is to keep the cost down. You know, if you're a doctor working for Concentra, you just want to get the person in and out and back to work as soon as possible.
Yep.
Because as much as you want to bill as well as Concentra and get money to do different surgeries and all this stuff and make a bunch of money, you also want to make sure that you're not making your customers angry by approving too much treatment and keeping their employees out of work.
Yeah, exactly. And you name drop there, and that's exactly what I was going for. Is that I've tried to go to urgent care once. Like, oh, do you have a work injury? I'm like, no, I'm having a problem with my head. I'm bleeding out of my head. Like, sorry, we don't treat those kinds of injuries here.
Yeah, exactly. And that's whenever you go to the ER or urgent care with an injury, they're going to ask you if it happened at work, because that insurance is going to kick in and precede any other type of insurance or payment for that injury. So that's why it's so important. And we've talked about it before. A lot of employers, especially for like construction jobs or labor jobs, they try to convince their employees not to make work comp claims. Do not do that. That's very illegal. Do not get yourself into dumb trouble for doing that. If you're an employer, you have to accept the fact that you are putting people in a situation where they might be hurt by virtue of employing them. And that's one of the risks that you have to take as an employer. If you want to be an employer, those are things that you have to deal with. People working for you are going to get injured. And yes, you're ultimately responsible for that. And you deal with that by getting insurance. Like, this is not something that you need to be lashing out against as, oh my God, I can't believe they're ripping us up. No, this is, otherwise you can't have a society. If people are not going to be treated well when they go to work and feel like their employer is going to be able to get away with just breaking their body and leaving them be, then nobody's going to do any work.
Well, and I think that you hit that on right. Is that civilized society requires like certain protections from employers to employees, and I think, and I don't know if the word illegal is correct, but I think it's illegal or unlawful for a business to not have um, workers' comp coverage with certain limits of liability, with which comes significant penalties and possibly jail time for employers in certain circumstances for their noncompliance.
I think
So,
Yale,
yeah.
Yale, you probably have to do something like, I don't know, super.
Yeah.
Uh,
Well, again, as lawyers, it's funny. My mom was a nurse. Growing up, my mom was a nurse. So like one day, I'd be like playing football outside with my friends or whatever, or skateboarding or something, and my mom would come home and be like, "You can never skateboard again." And I'm like, "What? What are you talking about?" She's like, "Oh, I had this patient come in who like broke his arm and like had a brain hemorrhage because he fell off a skateboard. Like the next day, it's like you can't play football anymore." It's like, "Why?" "Well, I had a patient come in today who you know died from a football accident or something." And so like that example is kind of like lawyers, where like we see the weirdest of things come to our desks because usually as lawyers, especially litigation, most of the stuff doesn't come to us like a run of the mill crap, right? Like, oh, like we have an employee who hit somebody. Like that's usually handled by insurance. Employers usually handle that correctly. But like we see the weirdest of things, and that's why the cases that come out like dynamics, where it's like we had never analyzed like the Barilla test needs to be simpler. We never analyzed like the stripper case, the apportionment of fault between one to another. Like those things come to us because they're not run of the mill. So we see these weird examples of like, well, hey, this client is a sole proprietor of a gas station, had no insurance coverage, and 10 employees later that all got killed at the job. Like now it's the 11th, and he's facing jail time for not having insurance. Like we would see those kind of cases.
That's true. Yeah, we're only going to see the special edge cases, and also the people we're going to deal with are also nuts, because the people that themselves into these situations are usually difficult to deal with, I should
Yeah.
say.
And just to wrap up kind of the investigation process of work comp is that, so we talked about what happens the day of the injury. Within 14 days after, the employer must report the injury or the injury to the claims administrator. That claims administrator has 90 days to accept or deny it. And then at that point, there's an authorization that begins of medical treatment for the employee if there's continuing treatment needed. And then every case goes through the kind of a normal process of were there witnesses, what happens, was there surveillance systems that caught it on video? What did the employee actually report at the time? Was it like a general, oh, I hurt myself, or was it, oh, I slipped and my left meniscus was torn 3 degrees? Was there a prior claim history or injury from the employee who reported it? And then questions and analysis of whether the injury arised out of or occurred in the course of that employee's employment.
So let's talk a little bit about Mr. Newsham's activities and if they were arising out of the course of employment and during the course of employment. So was the injury caused by a risk of the employment? So he blew out his knee while dancing. Is blowing out your knee an inherent risk while dancing? Yes, I would say so.
Well, unless you're dancing on your hands, I mean,
Oh, that's a good point.
right? Like if you're, but that's the thing though. It depends on the situation. I make a crazy example, like Cirque du Soleil people, like maybe breaking your neck while doing is not really inherent to a ballet performance, but breaking your neck is absolutely inherent to like a Cirque du Soleil show or like a trapeze artist show, right? It is,
Yeah.
yeah.
And then, so when he blew out his knee, was he performing work duties at the time? Yes, he was dancing on stage as he was contracted to with that trade show company. And he was on stage that they put on the time slot that they gave him under lights, presumably, that they turned on with
Carpet that they laid down.
exactly stage. So even with the causation problems that made this difficult for a tort case originally in Canada, he'd have a workers' compensation claim in California for sure. It doesn't matter in California what he slipped on, if it was his own baby oil, if it was some paint from another performer, or some inherent defect within the carpeting on the stage, it's covered.
The Berber was too thick.
Yeah.
Sorry, I have a really extreme knowledge of carpets.
Or North Africans. I'm not really sure.
Is that Berber? Is it the same term? Oh, I didn't know that. I learn something new every day.
So if he was an independent contractor, would he be able to sue? So of course we know this is kind of a legal fiction that we have to indulge ourselves in for a moment, a temporary suspension of legal disbelief to say that Mr. Newsham was legitimately a contractor. But let's say he was, would he be able to sue for negligence? And if he was able to sue for negligence, what would he have to prove?
Yeah, so the answer is yes. I guess the listener should have figured that out because when we spoke about employees, their sole remedy is workers' comp. So the answer is yes, independent contractor. And the negligence is a 4-pronged test. There must be a duty from the party that you're suing towards the person who is suing, so defendant to plaintiff. There must be a breach of that duty. There must be causation, and there must be injury. And that's a very blanket term. So like the duty, like let's talk about a car accident. A duty of someone who hits you in their car, they have a duty to drive safe, right? The breach of that duty is that person was not driving safe. They're speeding the speed limit. They're driving on the wrong side of the road. They blew a stop sign, blew a red light, whatever. The causation is your injuries were caused by that person's breach of the duty. So the person ran a red light and hit you. That's the causation. The injury obviously is the injury you suffered as a result of the breach of the duty. So
Here's the question I have. This is a little bit different though, because like in your example, let's say somebody hits you in a car, you don't have a contract with them, presumably, for them not to hit you with their car. There's no piece of paper that says this stranger is agreeing not to hit you, and so that's where the breach arises from. No, that's not it. In this case, there is a contract between Mr. Newsham, the dancer, and the trade show company, CanWest, that he's going to go up there and for his exhibitor rights in exchange.
Yep.
But in California, would it apply? And would the waiver apply to this injury? And There's a general rule that you can't contract out of ordinary negligence. That's not something you do. You can't have a contract or a waiver that says you waive any rights to sue me for damages if I've been negligent in any way. You can't do that as a business.
Yeah, this is why I don't read the waivers when I go take my kids to like the trampoline parks.
They don't matter.
Because yeah, because if my kid does something stupid and breaks their neck, that's one thing. But if they they fall through a trampoline because it wasn't maintained properly, they jump somewhere and it wasn't protected properly, that was general negligence, you can't waive that.
Yeah, you can't have a shittily run business and then have somebody sign a piece of paper and when they hurt themselves because of your shittily run business, say, well, you signed this piece of paper, so I can't get. That's not how it works.
Yeah, I remember but when I was in law school, we learned this. And I remember signing waivers that I provided to people for the clubs that we were running, the sports clubs we ran. And I remember telling people, you got to sign a waiver. And then I learned the rule. And then I realized after, as I signed every waiver for 2 or 3 years after that, I just signed and said audibly, can't waive negligence. I just signed it anyway because it didn't matter. Didn't matter.
Yeah, you cannot waive ordinary negligence. Sign whatever you want and happily sue them afterwards if they tell you you can't. Tell them to screw off and to listen to our podcast.
Yep, that's a big one to get new listeners too. And also, that this is a good time for our disclaimer, which we need to automate. Where you press a button and it says it, like with cool, like a cool, you know, the guy that does like the Supercross or like
Yeah.
like Monster Supercross. We are not your lawyers. This is not legal advice, and it's for entertainment purposes only.
Our own entertainment, because I don't.
Yeah. Hey, the listener. That's why I keep saying listener singularly.
I miss Dallas.
Yeah. Hi, Mom. But yeah, so again, this is our waiver, our typical disclosure here that we are attorneys. We are not your attorney. Do not take anything we say on the show as legal advice. It is simply for entertainment purposes only. We'd love to be your lawyer or lawyers, but we do not have a relationship with you yet. So you have to call us and sign an agreement and agree to all of our terms and pay us all that crap. But point being is that don't take any of this seriously. We are just doing this for entertainment purposes, and we are not your lawyers, and this is not legal advice. Okay, so going back. So I think here the issue is not the car accident, like I said, a duty to drive safe. The issue here, because it was more of like a slip and fall case or a slip and twist case or a pull twist case, that it comes down to premises liability. And then there's an analysis depending on what the law would classify Mr. Newsham as. If he's an invitee, there's a certain duty. If he's a licensee, then there's a different duty. And if he's a trespasser, there's no duty. So which one do you think would apply here, Arta? Was he an invitee, a licensee, or a trespasser?
I think in California, there's no distinction anymore between licensee and invitee. Isn't that right? Yeah, that's something I remember from tort.
Sounds right.
Not a trespasser. Obviously, he's not a trespasser. He's been invited to be there. That's a term of art. And they put him on stage to wiggle around for a little bit. So obviously they knew he was going to be there. They probably put him on some poster that said he's going to be wiggling around at 10:40. And I feel like at least that part would be satisfied. And I think what are their duties is the important thing. Between each performer, you probably have to have like a stagehand go and check the stage surface to make sure it's safe, or inspect it before people go on. Especially if you see them using liquid and stuff like that, it's going to be obvious. You're going to be on notice that there's going to be substances that could cause people to slip and possibly injure themselves.
Yeah, and that's exactly right. You have the highest duty you owe to your invitees. You know, you have a duty to inspect. You have a duty to make them safe. Your duty to warn, all that crap. High duty. And then trespasser would be hilarious if like a potential attendee to the show, I'm just trying to give an example for our listener here, is the attendee to the show didn't have a badge and didn't want to pay the presumably not high fee to get in for a tag, and just ran past the hired security guards who said, I ain't chasing that guy. I'm not paid for that. And ran onto the stage and did their own little number and hurt themselves. If that happened, there's generally no duty, because of one, you can't really prevent from unknown things, right? And two is that you can't warn the person that's running in as fast as they can to get onto the stage before they do so. So waiver.
So in your example, was this person sneaking in? So they snuck in. Let's say they were walking by the exhibition hall. They see that it's what was this, like, naughty nice night?
Naughty but nice sex show.
Okay, so the naughty but and they say to myself, "Listen, just my chance. I'm gonna finally get up on stage and I'm gonna break in," right? So that was okay. So what happens? That's clearly a trespass because they didn't pay for a ticket. They weren't allowed in any capacity. They're not performing there. They're not selling anything. They're not cleaning up. They don't work there, whatever. So what if it was somebody who was already like lawfully allowed to be there? Are they then a trespasser? Like, let's say you're an attendee and then you decide to run up on stage. Does the act of running up on stage turn you into a trespasser?
I believe so. I mean, that's a great question. I mean, you have a certain situation where you can protect against your invitees. Like, for example, if there's a big hole in the middle of the convention floor, you have a duty to make it safe and to warn them if you can't and all that stuff. But if that invitee is not expected to go in like the back rooms where like you have, dangerous sex toys hanging all over the place that could fall and hurt you, I don't know. That's a good legal question, and I don't know the answer. But I think my answer would be that no, at a certain point, their licensee status would be changed or invitee status would be changed once they exceeded the scope of that permission, and they would then become a trespasser. And then the second question I would have that I would need to know before I answered would be, is that person or group of persons who exceeded their scope of their permissions, did you know that was going to happen? Like, did you know that every show you have, everybody sneaks into the dildo room? Is that something that happens? We don't know. And if you know that's going to happen, and you know that's part of that they will exceed that scope, then is there a difference between you don't owe someone a duty that, seeks in, you never saw this person before, they didn't have a badge, versus this is going to happen because everybody does it at every show? Is there a different duty?
Again, it gets very complicated. Most of this stuff is just going to get settled before it gets to trial, and any of the legal questions actually get answered. So nobody worry about it. It all just comes down to what will the plaintiff take to shut up.
Yep, agreed. And just so everybody knows, we know the answers to these questions. Like, generally, to trespassers, you don't owe a duty, and there are exceptions if you know there's a trespasser. And a lot of times, like, at least from a business perspective, you see this where if you own a bunch of land, and you have a warehouse on part of it, and then your land is between like a road and the ocean, but a bunch of surfers go through your land to get to the ocean, there's a different standard if you know versus if you didn't know, and if those people were injured. So just again, we're not dumb, well, in that regard, but
Lane
yes, exactly. Anyway,
uh,
so now that we know that this person could sue, I know you said that you don't think the waiver would work, and that actually it wouldn't work, and you can't really you can't prevent someone for suing for normal negligence. Is there anything regarding causation that we need to talk about, or is it just they were hurt, then you're liable?
um, Yeah, I mean, I think, wait, in terms of work comp, yes, you're hurt, they're liable because it would happen during work. With the PI one, it's going to be a lot more difficult to answer the question because you're going to have to bring in experts to talk about the surface of the carpet and how it reacted with the oil and if the paint did anything, and find out from a paint expert if it was slippery, and have all these tests done, and check out the surface of his shoes, or if he was barefoot, or what the situation is. There's going to be so many things that go into proving this that as a plaintiff's attorney, I don't even know if I want to bother with this unless I have a bunch of younger attorneys where I can make them do stuff and don't care about their mental health.
Yeah, agreed. I mean, and just to kind of to emphasize what you said, like, I think the questions of causation absolutely matter in the PI context, right? Because a shrewd attorney or insurance attorney would say, well, wait a second, how'd you slip? Like, let's analyze this body paint. And then you're going to buy some of the body paint. You're going to have that expert, like you said, do the analysis on the carpet that they had. And you're going to have the body paint sit there for 4 hours and determine if it's still slippery. Like, who brought the baby oil? Did Mr. Newsham bring the baby oil? Did the company provide the baby oil? Was it leftover baby oil? Did P. Diddy leave the baby oil? Nobody knows. What else was in the baby oil? I mean, that's the questions that I guess the listener here wants to know today that we don't even know. And also, like, this pre-existing condition, I think, is a huge issue he's going to have to face because, again, work comp is a little different because the pre-existing condition wouldn't come in until the permanent disability stage. But here, the pre-existing condition would be a lot more, I think, beneficial for the employer for damages. And then in causation in civil cases, you have to show that the causation was a substantial factor in causing the harm that a reasonable person, again, funny in this context, would have considered to have contributed to the harm. It has to be more than remote or trivial. So that here in Newsham would need to establish that the slippery substance, to the extent that even existed, was a substantial factor in causing his injury, given that multiple performances after the body paint between, the 4 hours that the stage was used by the body painting and him, that, his own, the times he kind of walked on or danced on the same area of the carpet and didn't hurt himself, his use of the baby oil and whatever was contained in that baby oil, and then, his documented history of his knee locking up and being injured. So a jury would have to make a decision hilariously as to all of those things. And sitting, I can imagine being on the jury, sitting in a room with 11 of my peers saying, well, what kind of baby oil was this? We're gonna need some examples. Let's run some tests here and determine factually what happened.
Yeah, Johnson and Johnson versus store brand, all the different baby oils. Okay, so let's wrap up here. What do we want to tell people for the big picture? Basically, if you're in California, don't think that just because you have a contract with somebody that says they're an independent contractor, that they are not going to be considered an employee and that you're not going to have to cover them with work comp insurance.
Yeah, and I think the best way to do that is by doing an audit. Do a classification audit. Um, obviously red flags we talked about. If you set their schedule and you tell them where to be and how to perform or how to dance or how to use baby oil, that's one thing. If in the example of the exotic dancer, if entertainment is a regular part of your event, or if you're an HR company that hires an HR person as an independent contractor, clearly that's a red flag in California. If you provide them with equipment or computers or baby oil, I can't get over that one. Or if things like that, you want to make sure that you red flag that and you reclassify. Because again, reclassification, if you don't do it and you get sued for it in California, they'll undo that classification of independent contractor and come after you for all the other things like overtime, meal periods, rest periods, all those things. If you want someone to be an independent contractor, you make sure you use people who have their own established business. They have to control how they work and perform, have their own insurance, their own supplies, their own computers, their own tools, their own baby oils, all those things. And then make sure you hire someone outside of your normal course of business. So again, accountant hires a cleaner, not accountant hires an accountant.
And honestly, get work comp insurance if you're an employer. It's so important because it's going to save you a lot of headaches. Because if you get sued in civil court, it hurts a lot more than going through the work comp system. Just be very careful with the things that you do for your business and the things that you try to skip out on because you couldn't afford it.
Yep. And this is where another thing we've told you in a few episodes is hire an attorney. Like, yes, paying an attorney sucks. It's going to cost you money. Like paying money to anybody sucks really for things you don't think you need. But I guarantee you hiring an attorney will be a lot cheaper in the long run than just hoping for the best. Because if you think stuff isn't going to happen, look at this case from 2012 about this, or 2014, whenever the stripper exotic dancer falls on a stage at a trade show. I guarantee you that CanWest Trade Shows and whoever agreed to have this guy perform on stage in exchange for the fee for the booth never thought this was going to happen. And now you have two guys talking about it on a podcast that two people listen to. So I mean, imagine just a couple $100, maybe even $1,000 would have saved them so much time and effort. Because I guarantee you again that $1,000, again, if you would have paid someone up front to give you legal advice and done it correctly, $1,000 would have saved hundreds of thousands of dollars in litigation costs.
And you're a business owner. Again, this is stuff that you have to deal with. You are not going to be able to skirt this responsibility. If you're out trying to hire members of the public to help you make money, you have a responsibility to them that you can't get out of. You can't hurt them. You can't do things that damage them financially. Can't do any of these things. They're protected for it. And again, this needs to be in place for society to be able to work, because otherwise nobody is going to want to risk working.
Yep, agreed. And then specifically as like dangerous work environments, make sure you investigate and provide a safe working environment for your employees. Give them that high level of duty that you owe. Again, I
You can
guess.
still hate them.
What?
You can still hate your.
Oh yeah,
Yeah,
of course.
you give them all the insurance stuff.
Yeah, but do your jobs. I mean, like that's the worst part is it comes down to laziness. Like imagine owning a trampoline park and never inspecting the trampolines. Like eventually something's going to go wrong. Like imagine owning a strip club or a dance show and never inspecting the stage. Like you have to do these things. That's just part of the job.
So, anything else that you want to talk about before we wrap up here, or?
No, I'm good. I wish everybody a happy new year. I hope that everybody follows the law, and doesn't need an attorney ever. But if you do, I know of a good one, Law Office of Arta Wildeboer. Google it.
And thank you so much, Ryan. If you are looking for a great lawyer in San Diego, Ryan Ellis Law Corporation is available to serve all your legal needs. Well, not all of them, but he'll find somebody to do it, but he can't do it and then take the referral fee.
Yeah,
Awesome.
absolutely.
Anyway, signing off this time, and hope you guys have a great 2026. And I don't know if anybody's ever listening this far. Matt, all you.
Happy New Year.
All right.